Good afternoon, everybody. My name is Paul Gilbert. I'm the Business Development Director here at Dickinson Law. We're glad to have everybody here for the first part of our Avoiding Aggravation in Ag Lending webinar. Just a few housekeeping items today. We have a lot of information. As we go through, the handouts are available for you to download. At the end of the session, there will be a short survey at the end of the webinar as well, so we can get your feedback and ideas on future topics. And if you have any questions throughout, please enter them into the questions bar on your screen, and we will answer them at the end of the webinar if we have time. Otherwise, the attorneys will get to respond to your questions as we get them. So today we'll be talking about tax, foreclosure, and bankruptcy. We'll start off with David Repp, who will talk about some of the implications of the new tax law, followed by Mollie, dealing with agricultural foreclosure issues. And finally, Brad will be talking about preparing for and handling ag bankruptcies. So with that, we'll start with David.
Hi, good afternoon. So I have 2 or 3 topics to talk about this afternoon, one of which I just noticed is not a tax topic, but I thought it was a topic of interest that everybody might want to hear about. And it has to do with farmland partitions and those darn California cousins that cause so many problems for us. And let me tell you how this problem develops. The problem develops from farm estate planning, which may not have had a lot of thought in it at the time, but a lot of times we have a situation where one parent wants to treat all of the kids equally. We've got another parent that wants to carry on the family farm business as long as possible, and that's the priority for that person. So you got this conflict. Sometimes mom wins, sometimes dad wins, but oftentimes what we have is we have a situation where multiple children have an interest in the farm enterprise, and then that is okay for the first generation. Typically, everybody gets along for the most part okay. Second generation, not so much. Third generation, we have people scattered around the country who have an interest in a farm enterprise in Iowa where they've never even been and never even seen, and they want out. They want to cash out their inheritance that they got from great-grandma or great-grandpa. So farmland partitions, that's where this issue kind of comes up. Just to give you some background as to how this problem develops is that we may have 4, 5, 6, 7, maybe even 10 owners in common of a parcel of real estate. And these people may not always get along. We may have one local heir who is a farmer or farming that particular parcel, or sometimes we don't. Nevertheless, we could have 320 acres, we could have 500 acres, or even 1,000 acres of Iowa farmland owned by 10 or so individuals as tenants in common. Then, maybe you know this, maybe you don't know this, but the tenants in common, each particular tenant, doesn't have a lot of power or say over what happens to that farmland. You would think that that would be the case, that maybe they would have some sort of say in it, but they really don't. So if there's a farm tenant that maybe is a local farm heir, for instance, who is farming this land owned by 10 or so cousins from all around the United States, is that those cousins all over the United States really kind of just they can't really terminate that farm lease. They're just kind of stuck with it, even though it may be unfair in their eyes. So what remedy do those California cousins have? Well, they have a pretty strong remedy if they own a tenancy in common. That is, they can actually partition that farmland. And what does it mean to partition farmland? What that means is that any individual owner, no matter what size of the percentage that they own of that farmland, can go to court and they can require that property to be either one, sold and the proceeds distributed, or number 2, is chopped up that farmland so that the California cousin has a little piece of terra firma that he or she can call her own. So that's the focus of some Supreme Court cases that have come down in Iowa over the last couple of years. And the essence of the Supreme Court cases is such that the Iowa Supreme Court has mandated, more or less, that in most cases that the type of partition that's going to occur is going to be a partition by sale rather than a partition in kind. So you're not going to end up with a terra firma owned by a country cousin in that particular case. So this is where we're at right now on our screens. So we have the Supreme Court has pretty much just said that if you want to go down to a partition in kind, you have to do so by showing that it has to be equitable and practical for there to be a partition in kind. And what does that mean, equitable and practical? Basically what it comes down to is that you have to have some good money involved there. So if you have a parcel that was partitioned off that ended up being a 25-acre parcel of farmland in Iowa, and the value of that farmland is discounted pretty steeply because it's such a small little parcel, and then the Supreme Court of Iowa would say that that's not practical and equitable because the California cousin has taken a significant hit with respect to the value of his or her share. There's a recent case that came out just earlier this year, the Wilm case. It's an unpublished decision, but it more or less reaffirmed the case that in many situations it's going to be pretty easy to show that it's not equitable and practical to actually do a partition in kind. So that's kind of where we are right now. As far as ag lenders go, I wouldn't be too worried if we do a partition by sale. The mortgage gets paid off first before the proceeds are distributed to everybody else. Next topic is like-kind exchanges of machinery. That was a new change in the law that occurred just this last December. And normally, when you would sell or trade in a piece of equipment, a John Deere tractor, for instance, to get a new John Deere tractor, what would happen is that whatever the boot was that the farmer would pay for that new John Deere tractor, it would just pretty much have its own depreciation schedule, and you go on. It was essentially a mandated like-kind exchange. You trade in the old tractor for the new tractor, and you don't recognize any gain on the trade-in of that old tractor. That law has now changed. So no longer can we use 1031 exchange for machinery and equipment. You can't do it at all. So what happens is when you trade in that John Deere tractor for a new tractor, you have to recognize depreciation recapture on the sale price or the trade-in value of that John Deere tractor. And then you can start depreciating the full value of the new John Deere tractor. Now, for the most part, accompanying this provision where they took away the 1031 exchange for machinery and equipment in December, Congress also gave us a gift that now we have $1 million Section 179 depreciation deduction. What that means, essentially, is that when you buy that new tractor, for the most part, you can take that full value of that new John Deere tractor as a depreciation deduction in the first year. So even though you recognize a little bit of gain on the sale or trade-in of that old John Deere tractor, really for the most part, it's not going to have any bearing or effect because you're going to be able to take a huge depreciation deduction for that new John Deere tractor. Now I want to talk about a really interesting topic that is just a buzz in tax circles and agricultural circles, and it's the new Section 199A deduction. And you may be familiar with that. With essentially, generally, last December, Congress gave a big, huge tax cut to corporations, C corporations, publicly traded corporations. We took them from a top rate of 35% down to a rate of 21%. And then Congress thought that wasn't good enough because it treated unfairly small businesses that are organized as S corporations, partnerships, sole proprietors. And to kind of put them on the same level playing field, they gave them this deduction, this 20% deduction. So generally what it comes down to is that whatever income a partnership, LLC, S corporation, or even sole proprietorship generates with regard to its business, you get a 20% deduction for that. Now, there are some limitations on that. You got a wage limitation and all those things. But for the most part, that's kind of how that works. At the last second, and I don't mean last minute, I mean last second, before this Tax Act was actually approved and voted on by Congress, there were a couple of senators from North Dakota and South Dakota that inserted a provision in this new Section 199A deduction that ended up being a huge gift to farmers. And that deduction said that farmers not only get to take a 20% deduction of their income from their business, they get to take a 20% deduction of their gross sales from their business. Now, that's a huge difference, as you all know. A 20% deduction of net income is a whole lot smaller than a 20% deduction of gross sales. Now, when I first saw this, I thought for sure that was a mistake, that they didn't intend to do that. And there were some reasons why I thought that, which I won't go into now. But anyway, everybody else kind of believed, too, that, yes, that was a mistake. And even the senators themselves from North Dakota and South Dakota admitted that this was a mistake, that we really didn't intend to do this. And again, I could go into the details as to why they made that mistake. I really think it comes down to that most everybody who's in Congress doesn't understand our tax laws anyway, and let alone doing this within the last second of voting on a tax act was just crazy in my mind. But in any event, when I first saw this, I thought this is just going to be corrected. We won't get this. We won't get this 20% deduction for gross sales. But I've changed my mind recently. I now believe that this 20% of gross sales provision will stick and will be available to farmers. And this is only available to farmers this year, because there's another condition of this 199A deduction for farmers too, and that is that the deduction has to be a sale to a grain cooperative to get this 20% gross sales deduction. 20%, which is big. Where I think that Congress thinks that they made their mistake was that they should have opened this up to sales everywhere rather than just cooperatives. There are a lot of grain merchandisers out there who are not organized as cooperatives, who have been screaming foul at the top of their lungs. Companies like ADM and Cargill, who are not organized as cooperatives, are saying that we're not going to get any sales of grain. These are all sales going to go to cooperatives, and we're just going to take a huge hit. Now, I think that their argument doesn't carry a lot of weight because any sales that go to cooperatives will end up going to Cargill and ADM eventually, because cooperatives have to sell to an end user. So it'll all go to the right place that it needs to go. It's just that ADM and Cargill might have to pay a little bit more for it because we have to have this handling of grain from the cooperative to the ADM and Cargills of the world, rather than a direct sale to the ADMs and Cargills of the world. And that extra handling costs a little bit of extra money. So we have that situation. I think that there's going to be a change, a new legislation or corrected legislation this year. It'll probably happen in the form of, we're going to open this up to everyone rather than just sales to cooperatives, and we're going to keep the 20% gross sales deduction. Now, I'm still kind of shocked that we even have this special exception for farmers, because 20% of gross sales deduction will probably mean that most farmers won't have any kind of taxable income at all for this coming year, or for however long this continues to stay in place. That 20% gross margin is a pretty good margin for most farmers, and you take that as a deduction, and that means that they have no income. Now, that shouldn't surprise too many people, because if you look at this next slide here, this is kind of a little compilation that I've done for the last 7 years or so. And this is information that you can get online publicly through the IRS, and it shows reported farm income on that right column. And in the right column, all the text that's in black indicates a profit from farming. This is cumulative over all farmers in the United States. And any red text indicates a loss. Oh my gosh, there's no black text up there. I just noticed that. How about that? So farmers have never reported any income cumulatively over the last number of years. I thought that's interesting. So what is this deduction even going to do? Well, this deduction is going to help most farmers, who do show profits. And it's not going to help any of the farmers at all, of course, that don't show profits. I think that there have been quite a few. I'll just end on a note here. There have been quite a few players in the industry, grain merchandisers and vendors, who are rearranging their business structure to do what you would probably guess, to form and be created as a farm cooperative. This is happening. I got an article this morning from Reuters that indicated that Cargill and ADM have plans to mitigate this situation, to become cooperatives themselves, or have an arm, a sales arm, that would be a captive cooperative, essentially, that would capture all of the sales from farmers who want to sell to cooperatives. There is a Green Plains Energy, an ethanol plant, which has facilities all throughout the Midwest, has also created a cooperative, and it's all ready to go. It's not easy to be formed as a cooperative. It's about $100,000 or so is what this article says, to actually form and be a cooperative. But nevertheless, this is their plan. Also, I want to put this in perspective as well, too, from the farmer as well. So a farmer, if a farmer thinks he or she can save a penny in taxes, they'll spend $1 to do so. All right, and I'm not lying about that. I mean, that is just something that seems to be inherent in all farmers. And I'll put this out there too. I've come from a farm family. I'm still a farmer myself, so I have some credibility here. At least I think I do. But nevertheless, let's put this in perspective. Let's just say, for instance, that we have $4 corn, and we get to take a 20% gross sales deduction. So on this bushel of corn that we have here, that'd be an 80 cents deduction that we can take. All right. So what that 80-cent deduction means for the farmer, a farmer who is in the 22% tax bracket, which is reasonable, that farmer would essentially save 17.6 cents per bushel by selling his or her corn to a cooperative rather than to a non-cooperative grain merchandiser. Now, I can tell you, too, from experience, because I do still run a family farm with my family, that we sell almost all of our crops to a local ethanol plant and to a local end user, a large chicken farm in Dallas County, Iowa. And if we were to sell to a cooperative, our local cooperatives, and we have several of them, we take a pretty significant price hit, sometimes anywhere between 5 and 15 cent price hit. So if you think about this, if you're going to sell to a cooperative, and maybe you're going to sell at a discount, between 11 and 15% discount to a grain cooperative rather than to a local end user, merchandiser, really, you're not really gaining anything, right? Because you're losing money by selling to a lower priced provider, being the cooperative, in order to save a little bit of tax money at the end of the day. So anyway, interesting food for thought. That's all I have. There's my target. I am now going to pass the baton on to Mollie, I believe. Are you next?
That's right.
Okay, thank you.
Thank you very much, David. Hi, this is Mollie Pawlosky. We're going to switch topics up a little bit, moving on to the second topic of the three you're going to be hearing about today. And I am going to address agricultural foreclosure issues. I was particularly pleased that I've presented on this topic this year and last year both. I only do litigation. I tend to do foreclosures quite a bit, not exclusively these days, but I have had periods that's pretty much all I was doing was larger foreclosures. And I commonly like to use the Grim Reaper as my imagery. It's very appropriate when you're in a foreclosure situation, and it's unfortunately somewhat appropriate when you're talking about agricultural foreclosures. So I thought that was the way to begin this presentation. I'm also going to confess that agricultural foreclosures are rife with specific aspects that you simply need to review the code. That is, people that do it commonly are going to have the code at their hand at the throughout the process because there are a lot of specific provisions that need attention. You have to be very careful about them. And I begin with that disclosure because it's simply not the case that you're going to retain everything that I talk about today. What I'm hoping is that I can give you enough general guidance that when you're in the process and you are going through it, that you have a better understanding. Whatever lawyer you're using throughout the foreclosure process, whether it's this firm or another, will literally have the code beside them because they need to make sure that they're attuned to these aspects. Another point that I like to point out about foreclosures from the bank or financial institution point of view is that these are equitable proceedings. That has a significance for attorneys, but what it really means from the client or the customer or the bank position is that you don't have a jury trial, and as a result of the fact you don't have a jury trial, in most instances, the court will let virtually any argument and any type of evidence in if you actually have to try the case. I think that's important for financial institutions to be aware of because typically the arguments that the debtor will make are simply not going to carry the day. A lot of times the judge will simply want the debtor to feel as though they've had their day in court. Arguably, maybe the judge would want to avoid any kind of error by excluding information. So they're going to let everything in. And to the extent that you or your bank, your financial institution, find yourself in a foreclosure and actually trying it, don't be frustrated if you find that the judge is pretty much letting everything in. Usually that is not going to really affect the outcome of the proceeding at the end of the day. The purpose of my presentation today is to outline several special protections that borrowers have in the foreclosure process when we're talking about agricultural land as a secured property. The protections are numerous. We're going to talk about 6 today, and they really run throughout the process. Obviously, this is an example of a couple things. One might argue a strong farm lobby and how the farm lobby has maintained and been able to get these types of protections into the code. But also, I think just in general, the legislature, even if you're from a more urban or suburban location, you recognize the importance of the farm economy in Iowa, and particularly considering some very unfortunate historic periods, we want to make sure that we're giving these farmer debtors every opportunity throughout the process. So we truly are bending over backwards. From my experience in foreclosures, where there are a lot of aspects that help the borrower, the agricultural foreclosures have more protections than any other scenario that I'm familiar with. It's important to recognize in the presentation that I'm giving today that agricultural land is most commonly defined as land suitable for farming. That's the basic definition in the code, but you will find that dependent upon the code section you're relying on, there might be specific modified definitions that you'll be looking at. There are 6 different protections that we're going to talk about briefly today. I'm a little pressed for time, so again, I don't expect that anyone would be able to answer a quiz at the end, but I want you to be aware that there are notice protections, a requirement for mediation, certain preferences given in the receivership. The borrower will have an opportunity to request a continuance that other borrowers would not. The borrower will always have the right for redemption after the foreclosure, and even at the end of the process, the borrower will have a right of first refusal before there is any type of sale. So starting into the first protection for a borrower when a lender is foreclosing on ag land, you're going to have to give the borrower a notice to cure default. Because this is so prevalent and required in agricultural foreclosures, the code states a creditor shall not initiate an action to foreclose a mortgage on agricultural land unless the creditor has complied with this section. In virtually every foreclosure I have, the lender typically believes that they are required to give the notice to cure default, even if it's not required in the loan documents. And in what I'll call commercial foreclosures that are not for agricultural land, that is typically not required. You are not required unless your loan documents require it. There is no statutory protection. But again, because of our farm lobby or the approach we have here, you're going to have to give the borrower, the farmer borrower, the notice to cure default. And you're going to have to do it in a very particular way. But there are going to be a couple of instances where you don't have to give notice, and they're going to be very narrow. You're going to have to give that notice to cure default unless you've already given the notice with regard to 2 prior defaults, which means they've actually had 2 bites at the apple, and then this is the 3rd one. Or if you've given the notice once within the past 12 months, we're not going to require that you give the notice in this instance, or if the borrower has voluntarily surrendered possession. So in those instances, you will not have to give the notice to cure default. But in other instances, if you're dealing with agricultural foreclosure, you're going to have to give the notice. And the notice has a lot to it. The notice here has to be in writing. It is going to have conspicuously state, so you got to make sure it's going to be in a larger font or something like that that makes it clear to the borrower. Has to have the creditor name, address, telephone number, or other person to which the payment would be made. Has to have identification of the obligations secured by the mortgage. Has to explain the nature of the right to cure. Has to have a statement of the nature of the alleged default. It has to give a statement of the total payment, including an amortization of any delinquency or deferral charge. It has to state any type of other performance that might be necessary to cure the default. It has to give a cure deadline and as an exact date. And it has to include a statement that if the borrower does not cure the alleged default, the creditor or a person acting on the creditor's behalf can proceed with initiating a foreclosure action or procedure. If you do agricultural foreclosure as much as an attorney, you simply have a form or a template to make sure that you hit all these. You're going to have to, if you have any of them arguably missing or not present, you won't have given sufficient notice. And in this instance, if you have notice content that does not comply with the code, it's not going to be a claim or a defense of the claim or invalidate the foreclosure unless the borrower can argue that that failure to have that notice substantially prejudiced them. Again, in a court of equity, I think we're going to probably be a little deferential of what that means in favor of the borrower. So it certainly is better to make sure that you have a form or template and that you hit all those bases in giving your notice. We also have specific direction as to how the notice is delivered. The notice in this instance is going to be deemed received if sent by certified mail. The borrower has 45 days to cure the default after the notice is given. And the time period for a request for mediation, which we're going to talk about in a moment, also can run concurrently with this period. So you can send out your notice to cure, have that 45-day window start running, and then at the same time you can initiate the request for mediation and potentially see if that can occur in the same period. Until the expiration of the 45 days after notice is given, the borrower can cure the default. And what they do to cure is they tender either the amount of all unpaid installments without acceleration, plus a delinquency charge, which is the scheduled annual interest rate plus 5% per annum for the period between the giving of the notice of the right to cure and the tender. So there's a little bit of penalty there. Or they can then cure by paying the amount stated in the notice of right to cure, whichever is less, if it's a lesser amount, or you can tender any performance necessary other than non-payment if there's some type of default that was not a monetary default, and that which is specifically identified in the notice of right to cure. The act of curing the default restores the borrower to the borrower's rights under the obligation and the mortgage, except for it does count as the giving of a notice of right to cure for purposes of our counting exercise earlier. So they've had their first strike if they have been given the notice and they then cure in face of receipt of the notice. A borrower is not prohibited from voluntarily surrendering possession, and sending the notice does not prohibit the creditor from enforcing the interest at any time after complying with the notice requirement. So that's the first protection of the notice. The second protection given to agricultural borrowers in foreclosure is mediation. This is something that the lender must attempt. Of course, there's no guarantee of success, but you have to go through the process. And this is, again, one that most people are sort of conceptually similar with, that is only required in agricultural and only in certain instances, most of which are going to be satisfied, and that is you have to have a debt it has to be agricultural property, it has to be subject to a debt of $20,000 or more under the mortgage. Unless you get a mediation release, then you don't have to attempt mediation. There are going to be instances where a court could determine after notice in a hearing that the delay of mediation would cause the lender irreparable harm. That's fairly unusual that you would be in that situation, but if, for example, there was something unusual about the circumstances that the lender could show irreparable harm, you could give that some consideration. And title to land that is agricultural property is not affected by the failure to receive the mediation release, regardless of its validity. There was one case I wanted to point out that I don't have in the materials that had come down from the Supreme Court in 2013, and it's relatively unusual for the Supreme Court to address agricultural foreclosure issues, so I did want to draw the audience's attention to it. There was a case called Schaefer versus Putnam Law Office, an SMP, and I was a Supreme Court decision from December of 2013. It was essentially a procedural suit issued before the court, but it's something of may have some significance to the audience today, and that is in the SMP case, or the Schaefer case, what had happened was that there was a suit that was brought that was a breach of fiduciary duty suit where the plaintiff alleged that a mortgage that had been delivered to the plaintiff was unenforceable. So they were not directly attacking the mortgage, but they were saying, you breached your fiduciary duty to me. It was actually a very convoluted factual scenario. They were actually suing former counsel that had represented them, and they were saying that the consequence of the breach of fiduciary duty was that a mortgage that SMP had obtained was unenforceable. Well, what happened then was the defendant sat back and thought, you're putting the validity of the mortgage at issue. So I have to counterclaim, and I'm going to say that the mortgage is enforceable, and I'm going to seek to enforce the mortgage through a foreclosure. They filed their counterclaim. They did not attempt mediation before doing so. And they went through the process, and ultimately the district court said that that was appropriate, that they did not need to attempt a mediation before filing the counterclaim. Of course, it goes up on appeal, or we wouldn't be talking about it. And the Court of Appeals reversed and said, well, we look at the code section that requires the attempt at mediation, and we say that anyone who desires to initiate a proceeding is required to attempt mediation, and we're saying that you're desiring to initiate this proceeding by filing your counterclaim, so we're going to say that you had to attempt a mediation. So the Court of Appeals reversed the district court. The Iowa Supreme Court took it up on further review, and the only issue they looked at, and there were several other issues that had been hashed out in addition to this, the only issue the Supreme Court looked at is whether the creditor who was bringing this counterclaim was required to attempt the mandatory mediation. The short answer for purposes of today is that you are not required to try to mediate if you're bringing what's called a compulsory counterclaim. The compulsory counterclaim here was the plaintiff was putting the validity of the mortgage into question and was saying the mortgage isn't valid and we don't have to pay because this mortgage is bad. And the bank was saying, well, wait a second, we are questioning the validity of the mortgage and we think that you're in default under the mortgage. If we don't bring this now, there could be some adverse decision made that would affect our ability to enforce the mortgage in the future. So we have a compulsory counterclaim. It's based on the same transaction or occurrence. And if there's the same transaction and occurrence underlying the concept, you're bringing a compulsory counterclaim. And if you're bringing a compulsory counterclaim, you do not have to seek mediation first. From the lender's perspective, what this means in the future is to give careful consideration if there's a suit against the lender that raises the question of the validity of the mortgage. Think long and hard as to whether suit on or a claim back again with regard to the validity of the mortgage, would that be a compulsory counterclaim or not? It's probably most prudent to go ahead and take the steps to do the mediation. Yeah, that would never be problematic, But if it is not truly a compulsory counterclaim, the Schaefer authority would say that you do not have to attempt mediation in that instance, and you would be allowed to have your counterclaim proceed. The next preference or protection that we're talking about for agricultural borrowers in foreclosure are certain receivership preferences. Receivership preferences as to how the receiver is appointed, how the profits of the receiver are applied, and then at the end, the right of first refusal and how that works in light of the receiver here. All foreclosures, if you have any type of foreclosure, the owner or person in possession is given preference to lease the mortgage premises throughout the duration of the foreclosure. There's always court approval necessary for that, but that's the preference given. In agricultural foreclosures, the preference is that if a receiver is appointed, if you have agricultural land, the owner or person in possession shall be appointed as receiver without bond, provided that all parties agree to the appointment. So there's a slight preference that it's required, it shall be appointed, and there's no bond that's required in that instance, which typically there would be a requirement for receiver bond. The agricultural borrower also has additional priorities as to the application of rents or profits during the receivership. There's a statutory hierarchy as to how those costs are paid. First, the receivership costs go to the cost of the receiver, then taxes, then we have insurance, and lastly, as determined by the court, the balance is then paid as determined by the court. That's how the priorities work with the agricultural receiver. If the owner or person in possession is not afforded, let me take a step back. There are two different types of priorities given with if the owner or person in possession is not afforded right of first refusal in leasing the mortgage premises, as we talked about the priority given, the owner or person in possession has a cause of action actually against the receiver to recover either actual damages or a $1,000 penalty, which can include attorney's fees. So that's a significant deviation from the commercial context as well, because typically there is no cause of action that arises if the owner is not given the right to retain possession of the property during the receivership. Also, another priority that's given to the borrower, the receiver shall deliver notice of an offer made to the receiver to the owner or the person in actual possession, which contains the term of the offer and the address of the person making the offer. That has to be done, delivery has to be done personally with return receipt or certified or registered mail, and an offer shall be deemed to have been refused if the owner does not respond within 10 days after the offer is made. Another significant pre-foreclosure protection, the borrower is allowed to seek a continuance. The purpose of this section of the code was to allow the mortgager the chance to refinance or to pay up the indebtedness and save the farm within the moratorium period. In all actions, when the owner enters an appearance and files an answer admitting some indebtedness, those admissions cannot be withdrawn or denied after continuance is granted. The owner can then apply for a continuance of the foreclosure action if the default is, or the inability to pay was brought about by drought or flood, heat, or other climactic condition or infestation, so something that was beyond the control of the debtor. Application has to be in writing and has to be before a final decree. So again, this is earlier in the procedure. And upon the filing, the court sets a hearing and then gives notice. If the court finds that it's made in good faith and that the finding of the drought, infestation, etc. is satisfied, then the court grants the foreclosure continued in one of two ways. If the default occurs before the first day of March of any year, causing the loss and failure of crops on the land involved in the previous year, the continuance ends on the first day of March of the succeeding year. Or if the default of the terms of the note occurs after the first day of March but during the crop year, and the crops the year's crops fail by reason of any of the causes set out, the continuance ends on the first day of March on the second succeeding year. So those would be the two instances for the continuance. You only get one continuance except for extraordinary circumstances. Typically, it's not going to exceed a year. And the order would appoint a receiver, which is again going to have certain proceeds dictated. And one of our last limitations upon the lender, you're never going to be able to foreclose without redemption. You always have the right to redeem if you have a foreclosure of land that's used for an agricultural purpose. And agricultural purposes are specifically defined by the code, as are agricultural products. And in general, if you satisfy the agricultural purpose and the agricultural products, you're going to get a 1-year redemption that can be extended for a period up to 5 years by written agreement. Before redemption, the debtor is entitled to possession of the land, and you can't redeem if you've stayed execution. And if the lender is the winning bidder at the sale, you're going to get a certificate of purchase instead of the deed, and then after a year, you're going to change that in for the sheriff's deed. And the final protection that the borrower gets in an agricultural foreclosure is you're going to get a right of first refusal following the recording of the deed. When the deed is for agricultural land, we're going to give the right of first refusal for 1 year. The grantee records the sheriff's deed within 1 year and 60 days from the date of the sale. And within that period, we're going to give the grantee options that are not available if we don't have we're going to give the debtor options that are not available if you don't have an agricultural foreclosure. There are also additional requirements than if you have public auction or private auction that I'm going to jump through here because I'm getting over my time. And lastly, I'm going to point out that an overlay for all of the foreclosure, you have to give borrower a 14-day demand payment of accelerated balance before you file but after the cure period, or you're not going to be able to request an application of attorney's fees. The judge will always decide if the fees are reasonable and necessary, but if you haven't given the 14-day demand, you're not going to be able to request fees in your foreclosure. So now I'm going to transfer this over to Brad Kruse, who's going to talk about certain bankruptcy aspects that pertain in the agricultural arena.
Thanks, Mollie. Hi, I'm Brad Kruse, and I'm going to talk a little bit about bankruptcy implications, but also pre-bankruptcy stuff as well. So here goes. There's me, and let's talk a little bit about pre-bankruptcy considerations, or what I've called dealing with debtors in the shadow of bankruptcy. And this would encompass a distressed loan situation or a troubled loan situation, and some things to look at, even though they may not be in bankruptcy. Maybe a bankruptcy is being complicated or contemplated, but maybe they're not even thinking about bankruptcy yet. The loan is just stressed. In this situation, it's important that the bank evaluate its options and available remedies as quickly as possible, because if you've been in one of these things, they can go south pretty quickly. And the best way to do this is to promptly conduct a thorough due diligence review of the borrower's situation. And what this would mean, it would be review the loan documents that are in place. Has everything been properly executed by the parties? Are all the signatures obtained, or all the documents where they're supposed to be, everything properly dated? Sometimes you find some inconsistencies and problems. It's better to identify them and try to correct them at that point, rather than to let it get any further down the road. Review the UCC filings. Is everything up to date? Was everything properly filed in the first place? Are all financial covenants and ratios in compliance? That's something to look at. And you want to obtain new tax searches and lien searches, judgment searches on the borrowers and guarantors to try to determine what that situation is. One of the most important things to do in a distressed situation, and as we'll cover a little bit in a bankruptcy situation, is the collateral secure? Is it where it's supposed to be? And one of the things that you need to do is try to conduct on-site audits and reviews of your collateral. I've had numerous situations where we've had maybe the collateral is a herd of cattle or pigs, and if you're not out there monitoring what's going on, that can deteriorate. The health of the livestock can deteriorate very quickly. A lot of times in a distressed situation, there'll be an inclination to maybe skimp on supplements and so forth and things for the herd. And so you want to make sure that you're on top of that. And you also want to make sure that the grain is being, if you got grain as collateral, is it where it's supposed to be? If it's being sold by the debtor, is the bank's lien being honored, or is the debtor trying to move it somewhere else, hide it somewhere, or try to sell it at an elevator that doesn't recognize or isn't aware of the bank's security interests? So that's a very important situation to look at. You want to evaluate other secured creditors, and if so, what are the lien and security interest priorities there? You want to get copies of the borrower's current and historic balance sheets, incomes, statement of cash flows, in order to make a realistic determination on how the borrower's business is trending and what the borrower's future abilities may be. So if the borrower's is not trending, borrower's financials are not trending too poorly, you can consider restructuring the loan, negotiating a loan modification, or possibly entering into a new loan arrangement. One caution about entering into an entirely new loan arrangement: if you enter into a new loan arrangement, any defaults of the borrower and any of the lender's rights under previous defaults are going to be terminated. So sometimes it's better to simply modify the existing loan documents and so forth. And one of the most common ways to do that is with a forbearance agreement. And I won't spend too much time on this in our next session. A week from today, Ben Bruner is going to spend some time talking about this. But forbearance agreements can be a very, very powerful and significant tool for banks in distressed loan situations. In contrast to simply amending the loan agreement or entering into a new loan transaction, the forbearance agreement keeps the borrower's default in place, and it provides additional leverage and consideration to the bank in exchange for the forbearance of its rights that stem from the borrower's default. So you keep the borrower's feet to the fire, you get some additional consideration for the forbearance. And some of the key elements that can be used in conjunction with a forbearance agreement include adding extra security interests and additional collateral, or to perfect previously granted security interests, and you can do that in the forbearance agreement. Some other terms that you can put in a forbearance agreement include the waiver of the automatic stay if the borrower eventually files for bankruptcy, so that you can proceed against the collateral. You get potential release of lender liability claims that can be helpful. And some of the most important things to put to have in a forbearance agreement are simply the borrower's acknowledgement of the debt, the borrower's acknowledgement that they're in default, the borrower's acknowledgement that they don't have any claims against the lender, and so forth. And so I I would strongly urge the use of a forbearance agreement because it can have a good impact, and it can minimize the impact of a subsequent bankruptcy filing. Now, let's say all despite your best efforts to work out a satisfactory either refinancing or workout, and despite the fact that maybe you've even entered into a really nice forbearance agreement where you forbeared for the banks decided to forbear its right to proceed promptly against the collateral. You gave the debtor some breathing room, but they still went ahead and they filed for bankruptcy. So now what do you do? And the most important thing to keep in mind is don't give up and don't feel that all is lost, because there are a number of very powerful creditor remedies in bankruptcy, in a bankruptcy case, that are available to creditors, especially to secured creditors. Some of the first things, well, actually, let me talk just a little bit about overview of the various chapters. Chapter 12, of course, is the is applicable to a family farmer bankruptcy. It's sort of a hybrid between a Chapter 11, which is standard business reorganization, although Chapter 11 is open to individuals as well. So you might see a farm Chapter 11 case. Chapter 13 is sort of an individual wage earner bankruptcy, where the debtor commits a certain amount of its monthly income to a plan over time. And so Chapter 12 is fairly close to a 13 in that regard, but it's got some broader aspects that are closer to Chapter 11. The key to a Chapter 12 is that or some of the keys are that the debtor's got a limit on debts of $4,153,000. So if the debtor's trying to discharge or work through more debt than that, Chapter 12 is not going to be available. And it's only available if 50% of the gross income of the debtor is from farming operations. The time frame on a Chapter 12 is that a plan must be filed by the debtor within 90 days. Secured creditors must receive the fair market value of their collateral in the plan. There is an ability in Chapter 12 to file multiple amended plans, and in doing so can potentially extend the time of a Chapter 12 or the duration of a Chapter 12 case for a number of months, maybe even up to a year or over a year. I've seen those go as long as the court believes that the debtor is making some progress towards a plan. Chapter 11 is very similar, a little more time frame in terms of filing plans of reorganization there, and so those could potentially take even longer. But some very important things to do at the start of a bankruptcy case. You've got to stop collection activity because of the automatic stay on the old debt. But you should continue to do and conduct due diligence. And part of this is thoroughly reviewing the debtor's schedules and statement of financial affairs. There's going to be a plethora of information that's in those that's required to be filed in conjunction with the bankruptcy. And you're going to get a lot of that information on their assets, their income, and what drove them to bankruptcy, financial transactions that they've made over the past few years. All that's going to be provided in the schedule of financial affairs. And many times, what they've provided may be different and somewhat conflicting with what they've provided the bank, in terms of personal financial statements and financial information before. And if that's the case, if what they've provided the bankruptcy court doesn't match up what they've provided you in the past, there's the ability to take some action, and if it's material and it's to the level of really like a significant misrepresentation of their assets or hiding of transactions they engaged in, and they haven't told the bankruptcy court about it, they could be in the territory of getting their bankruptcy dismissed. So that's very important to take a look at that. Again, take a look at where the collateral is, and make sure the collateral is secure, or your collateral is secure and where you think it should be. If it's not, you have the ability to take immediate action with the bankruptcy court to lift the automatic stay and go after your collateral. Just because the bankruptcy is filed doesn't necessarily mean that the debtor is going to protect your collateral, so it's important to continue to monitor it. Talk about some of the big, moving on, let's talk about some of the big remedies that are available. We just mentioned relief from the automatic stay, which is a motion that's made to allow the creditor to proceed against the debtor because they're not protected. One of the main remedies to use at the start of a case is an objection to the debtor's use of cash collateral. And that's going to be prevalent in a Chapter 12 case or a Chapter 11 case. The debtor has to have the bank's permission to use the bank's cash collateral. And what do I mean by cash collateral? That is cash, accounts receivable, and inventory that's on hand. And for the debtor to use that, they either have to have the bank's consent, or the debtor has to have gone through the bankruptcy court to get authority to do that. And if it looks like the bank's collateral is going to be dissipated throughout the course of the bankruptcy, or is currently being dissipated, the bank can object to the debtor's use of cash collateral on the grounds that it's not adequately protected, which essentially means the bank is going in and saying, listen, we're going to be worse off here if we let the debtor continue to use our cash collateral. It's just going to waste the cash collateral, and it's going to be gone. So I'm going to move on. We've talked about the automatic stay a little bit. I'm going to move on to fraudulent conveyances here. Fraudulent conveyances are a possible avenue of recovery for the bank. If you can either proceed under Bankruptcy Code Section 548 or Iowa Code Section 684. So Iowa Code Section 684 has a longer reach-back period, and this can be a very powerful remedy for creditors, especially secured creditors, if the debtor has sold or conveyed or transferred assets without fair market value consideration. Another remedy that the bank has is to object to the debtor's claim of exemptions. Bankruptcy Code Section 522 provides a bunch of exemptions. Iowa Code also has a list of exemptions which apply to debtors, and oftentimes the debtors will be very liberal with the exemptions that they claim, and claim exemptions above and beyond what is provided in the Bankruptcy Code and above and beyond what's provided in the Iowa Code. And it's very important that the bank, if it's aware of that situation and it affects the bank's collateral, to go and object to the exemption, because in that situation, even though the debtor may have claimed an exemption beyond what's provided by law, the Bankruptcy Code provides that if no objection is filed by a creditor, the debtor essentially gets to keep the exemption claim. So it's important to go in and be vigilant and object to the claim of exemptions. Set off, another powerful remedy for creditors. It's most commonly used in this situation with banks where you've got deposit accounts that are held, and the debtors may be not making the loan payments that they're required to make, and most loan documentation provides the bank with the ability to either sweep the account or offset the account, even if your loan documentation doesn't necessarily provide it or doesn't provide clearly for it. It is a common law statutory a common law right that exists in virtually every state to exercise your set-off rights. The key component there to remember is if you want to exercise your set-off rights after the debtor has filed bankruptcy, you need court approval to do that. You can't just go in and sweep the account after the bankruptcy's been filed. That would be an automatic stay violation. It could cause all sorts of problems for the debtor and have all sorts of contingent problems, and so you have to get court approval first. If the exercise of set-off isn't likely to hurt the debtor, the court's likely to grant it. If a bankruptcy hasn't been filed, you've certainly got the option to exercise set-off rights without any kind of court approval whatsoever. The only caveat there is if you have a reason to believe that the debtor's bankruptcy filing is going to be imminent, and you exercise your set-off rights and you improve your position vis-a-vis other creditors, it's possible that the exercising of the set-off rights in that situation will be deemed a preference. My advice to people to banks in that situation, or any creditor in that situation, is typically to go ahead and exercise the set-off right under the premise that a bird in the hand is generally more valuable. And if the debtor does file bankruptcy within 90 days after that, and there's a preference problem, it's better to have to possibly give money back at that point than to have foregone the opportunity to missed out on the ability to exercise set-off, because who knows, the debtor may move the funds somewhere else and you may not have that option. Next and last remedy is discharge and dischargeability. These are a couple of items that are very powerful as well. Section 523 of the Bankruptcy Code gives you the ability to object to the discharge of the debtor's debt to the bank in the event that the debtor obtained that debt through false pretenses, fraud, false misrepresentations, and so forth. A prime example of that is if the debtor provided financial statements and other financial information in writing that was inaccurate to induce the bank to enter the loan in the first place. And second of all, Section 727 is a broader objection. It's an objection to the debtor's discharge in general, not just an objection to the debtor's discharge of its debt owed to the specific creditor. It's an overall objection to the debtor's discharge that applies across the board, and that's in the event that the debtor engaged in some improper conduct, didn't comply with the bankruptcy code rules and formalities after the bankruptcy was in place, or hid assets or misrepresented anything on the bankruptcy schedules. A 727 objection is possible. As far as strategic considerations, I generally believe it's better to go under Section 523 rather than both. You see a lot of times where both is claimed, or both options are claimed. If you get the broader discharge under 727, that means, or object to the discharge under 727, that means that all creditors can come back against the debtor for the debts owed. If you merely go under 523, the debtor gets a broader discharge against all the other creditors except you. You're generally in a little bit better situation in that regard. So my time's just about up, so I'm just going to say, reiterate that it's very important to be diligent at the start of a bankruptcy case or the start of a troubled loan. Do your homework, and there's a lot of options available, both pre and post bankruptcy filing, that can be very helpful and powerful to you. So that's the end of my talk. Next Tuesday, February 27th, we're going to have Jeff Baxter talking about essential provisions in loan documentation. Ben Bruner is going to talk about agricultural loan modifications, workouts, and non-judicial alternatives. And we're going to have John Landy talking about organic farming. So we hope that you'll tune in next Tuesday at noon, same same bat time, same bat channel, as they say for that. So we appreciate you being in attendance today. And if you have any questions for either Mollie, for David, or myself on any of our presentations, feel free to call us or email us, and we'll do the best that we can to answer them.
All right. Thank you. That concludes today's webinar. We will let everybody get back to their day. It's a little bit after 1. Thank you for taking time, and we will see you next week. A recording of this webinar will be made available as soon as the system compiles it. We'll send that out via link as well as handouts for everybody as well. So thank you very much, everybody, and have a good day.